One. I will just let you know when you can start speaking, okay?
Sure.
George, you are good to go.
Thanks everyone for joining us today. I'm Jason Kardashi. I'm a managing director in Kroll's restructuring business, responsible for Asia. And joining me is George Gui, a director in my office, and he's assisting managing this matter. Nishal Shetty, one of the founders of WazirX, is joining us today, and will also be presenting. We have some slides for you. This is not, given the number of users and the people that we expect to join, it's not an interactive session. So we'll be presenting some slides, and at the end we have received a lot of queries, a lot of questions. We've collated them into the most common questions. We will be answering them at the end, and we'll be providing copies of this to the users following. We will encourage you to send your questions and anything that comes during this discussion to our email, and we will be answering those questions as diligently as we can. So we're here because there was a cyber attack that occurred on the 18th of July to WazirX. We need to develop a solution for the crypto balances that are held before we can resume crypto withdrawals. This restructuring of crypto balances is being conducted in Singapore under a scheme of arrangement. That's a process that we will explain to you shortly as to how it works. It's something that takes around 6 months, and it is, in our view, the fairest and quickest way to achieve a resolution here. It is one where creditors have input into the process, and it has to be approved by creditors, and it is a legally binding solution to these problems. There are obviously a lot of creditors, and some have different views, and we're not going to be able to distribute back the crypto balances until we get a resolution to this. This scheme will allow us to improve recoveries to users as well, which I'll talk about how shortly. We have applied for a moratorium in Singapore that gives us the time needed to develop this restructuring proposal. The moratorium gives us, from the 27th of August, automatically 30 days of protection, during which time the Singapore court will decide whether or not to grant a moratorium, which will allow us to proceed with this restructuring. We believe that this is in the creditor's interest to support this moratorium, and we have already had substantial support from creditors for this. We ask that you do indicate your support as well. What we're aiming to do with the restructuring is to distribute the tokens that we have, the remaining tokens after the cyber attack, to users in a pro rata, equitable way, and importantly, in crypto, not in fiat. We're hoping to improve recoveries to users through primarily 3 ways. We're talking to investors, potential white knights who may provide capital to us in order to pursue potential partnerships and collaborations with them. There are revenue generating profits and mechanisms to share profit that we generate with users in coming years. And we are working hard to trace and to recover the stolen crypto assets. Through a combination of these efforts, we hope to improve recoveries to users beyond the amount that we currently hold. It's too early to say by how much it may be possible to improve, but full information will be provided to you as this restructuring process continues. I'd like to hand over to Nishal Shetty to talk about the current situation and why we're here.
Thanks, Jason. And hi, everyone. I just wanted to give some background about, WazirX. And as a lot of you know that we launched WazirX in 2018. And soon after there was a banking ban. And in 2019, we sold WazirX to Binance. A few months after that, the Supreme Court, turned down, the banking ban was lifted by the Supreme Court in India. And that's when our India entity, Zanmai, came into the picture. And it started the INR deposits and withdrawals for everyone. And this was after the Binance acquisition in 2019. In 2022, late 2022, is when there was a dispute between Binance and Zettai, the Singapore entity, on the ownership of WazirX. And in 2023 is when Binance seized the crypto wallet operations, and Zettai had to take custody of these assets. So 2023 is when Zettai took custody of the crypto assets, and the position of Zettai, the Singapore entity, has always been that the ownership and the deal was done in 2019, and the transfer happened. Now that's under dispute, and we can't talk about it due to confidentiality. Having said that, the question is, how do we resolve the current situation? And that's where Zettai is stepping in. Yeah, we can go to the next slide. I want to shed some light on the incident itself, the cyber attack that happened on 18th of July. This was an attack on one of our cold wallet, which had Ethereum and ERC20 tokens. And this cold wallet, we were using Liminal's infrastructure to secure this and to manage it. And there were 4 signatures required for any transaction on this wallet, of which on the day of the attack, the 3 signatures were done by WazirX, and 1 signature was done by the service provider, which is Liminal, which was supposed to be the final signature after going through all of the checks that are necessary in order to ensure that the transactions are correct. The involvement of the WazirX team was to use laptops and hardware devices to sign these transactions, and they saw a particular transaction on the screen of Liminal's website, which said that they were doing a transaction for Gala tokens, and they went ahead and signed it. And on Ledger, there's blind signing, so you don't really know exactly if what is shown on the screen is the same that Ledger is showing you. And this is where the attack would have originated in terms of why this was signed. But the 4th signer, which is Liminal, that's not a human there, and we are still awaiting details on that. Having said that, what we did was we immediately had we put a withdrawal freeze on the platform on the same day. We also stopped trading. There was a time period, where trading continued. After the attack, we did an undo of those trades as well. Brought the balances back to the day of the attack. Yeah. Can we go to the next slide? Now the question is, after the attack, what are the things to be done? And we've been every week going after a variety of efforts towards recovery. So one of the priorities is how do you recover these stolen assets? And for that, the first phase was to ensure that you go to the relevant authorities, law enforcement, you bring in the right, I would say, teams that are experts in this. We also wanted to make sure that the attack did not involve any compromise of WazirX's 3 laptops that were used. And I want to clarify that this did not involve the WazirX infrastructure or the product or the servers. It was just these 3 laptops that were used to access the liminal website for signing these transactions. We got one of the industry's best forensic team to analyze these 3 laptops, and they've given a clean sheet to these 3 laptops that WazirX used for signing. We definitely await now liminal's side of things. We haven't gotten any information yet, but we wait for them. But at the same time, we've also we've been working with law enforcement, and we're pursuing all possible options to make sure that one, we find the perpetrators, the culprits. We work on recovery. For recovery, what we've done is we've reached out to over 500 exchanges and platforms where the funds might possibly land, because right now we can still see the funds on a blockchain, on the blockchain, and we know that these funds will start moving, and when they do move is where the opportunity lies to get them frozen and get them recovered. And that's a ongoing activity. It's going to take longer, but we'll be after it no matter what. We want to make sure we try to recover as much as we can. And we are also working with authorities in different countries as well, wherever there's a possibility of reaching and getting these funds recovered. We're going to try all of those opportunities. But yeah, this is a top priority for us. Yeah, can we go to the next one? While this whole crypto, unfortunate crypto attack that happened, and we're working on recovery, we're working on restructuring that we're going to talk about today. There is the India entity Zanmai, which, like I previously said, came in when INR operations started in India after the banking ban in 2020, which was after the acquisition of WazirX. So Zanmai, handles the INR deposit withdrawals and the INR trade, and INR is not affected in this. So all of the INR is present with Zanmai. There's about 34% that's a matter of some disputes, and a large part into Indian law enforcement investigations. And we are working actively on all of these to get them unfrozen. But in the meantime, the 66% that exists, we are distributing that to all of the users. And we've opened up 33%. The idea is to open the second part, the other 33%, from 9th September, but we are trying our best to see if we can do it faster. But yeah, be rest assured that the remaining 34% also we are actively working on that. And the idea is to get them released sooner than later. And we'll let you know as soon as that happens. Yeah. I would like to hand over this next slide. I think George can take it. George is from Kroll. George, over to you.
Thanks, Nishal. Hi, everyone. My name is George. I'm a director with the Kroll Restructuring team out of Singapore. I'm working with Jason and Nishal on this particular engagement. Now that INR withdrawals have been opened, the platform still needs a solution for crypto balances. Unfortunately, for crypto balances, it is not as straightforward as INR, given that crypto balances were impacted by the cyber attack. Earlier last week, on 27 August 2024, Zettai filed a moratorium application with the High Court of Singapore. And what this does is provide Zettai and the platform with the time and breathing space to develop a solution for the cryptocurrency balances, which we intend to deliver by way of a restructuring under a scheme. Nishal alluded earlier to the ongoing dispute with Binance. And however, notwithstanding this ongoing dispute, Zettai is proactively stepping forward to propose a restructuring of the crypto balances under the Singapore Scheme of Arrangement. We refer to this as a scheme. And we're doing this because it's in users' interest to arrive at a solution for the crypto balances as soon as possible. The alternative would actually be to wait for the resolution of this ongoing dispute, which is an uncertain process with uncertain timelines that are subject to confidentiality. So unfortunately, we are not able to share very much on this. Now, under this proposed restructuring, platform users with crypto balances will be contingent, unsecured creditors of Zettai who can vote on the restructuring and a scheme. There are plenty of words here that many of you may not be familiar with, and we'll go into a bit more detail in subsequent slides to explain them. But first off, let's start with a financial position review. What we see here is one side of Zettai's balance sheet, the assets, as valued as at 23rd October 2024. On the leftmost column, you see the asset type, and we have the top 10 tokens there, along with other tokens in fiat. And another way to classify this is based on liquidity. You will note from the second column, the top 11 rows are listed as liquid, and there's a row below, second from the bottom, listed as illiquid. Liquid assets refer to assets that are under Zettai's control right now, in a range of wallets and on third-party exchange platforms, whereas illiquid assets are not under Zettai's control. We have a row of contingent illiquid assets worth 17.7 million USD. These assets are presently not under Zettai's control, and we will need to undertake active recovery efforts to realize these balances for the benefit of creditors. In total, we have $284 million worth of liquid assets, comprising the top asset is BTC, worth approximately $70 million. And as we work down the list, BTTC is the smallest of the top 10 tokens, worth $7 million, with $72.8 million of other tokens in fiat, for total liquid assets of $284 million. Adding that to the $17 million of contingent assets, we arrive at an asset position of approximately $311 million. Now, I would like to flag that in addition to what you see represented in the table here, $12 million of crypto has been set aside and earmarked to fund expenses expected to be incurred in the next few months as we pursue a restructuring. These expenses will be primarily for a few different kinds of expenditure, one of which, and absolutely essential, is to fund ongoing operations of the platform to keep it operational, functional, and a going concern in the absence of actual ongoing trading, which could potentially fund ongoing costs. It's absolutely essential to maintain the platform because the platform's infrastructure and capabilities will form the basis of subsequent restructuring, including the generation of future revenue products under a proposed restructuring. There's also funds set aside for investigations to pursue the stolen assets through blockchain tracing, forensics, and recovery efforts. Costs associated with the restructuring, and costs associated with restructuring will be necessary to comprehensively generate a restructuring proposal. There will be a consultative process. It's not the case that we will be going forward and just putting a plan, but we will be taking feedback on the plan and ensuring that whatever we ultimately put to creditors for a vote can reasonably be expected to pass a creditor's approval vote. Given the sheer size of the creditor base, approximately 4.3 million active users with cryptocurrency balances, there's going to be a significant amount of community outreach and effort and time taken to carry out these outreach and feedback solicitation processes. Lastly, there are also legal costs associated with ongoing proceedings, which presently are under confidentiality. This is the page setting out a snapshot of the liabilities, which is the other side of Zettai's balance sheet. These are valued as at the withdrawal freeze. In total, Zettai's platform users comprise both individual and corporate platform users, a total of approximately 4.3 million creditors, holding approximately 546.5 million USD worth of claims. These claims have specific nature, which is listed in that column, and these claims are contingent and unsecured claims against Zettai. I would like to flag an amendment you can see in subscript just below the table, where basically we generated a correction for the number of creditors and value of claims that was put to court in the moratorium application earlier last week, following some adjustments and error correction internally. What you see on screen is the latest position on the number of creditors and claim amounts, and we are intending to file a supplementary affidavit in the coming weeks to ensure that this amendment is adequately reflected in the court's records. Besides the liabilities listed above, Zettai also has about $247,000 worth of trade payables to third-party suppliers, and these relate to costs of operations and ongoing legal proceedings. Lastly, there are $28 million worth of token balances that are held on trust by the platform for various Indian law enforcement agencies. What you see on screen in the liabilities table and on the previous screen on the assets table do not include any of these token balances or trust claims, because they are not contingent and unsecured claims. They are trust claims, and thus have been set aside separately from the broader contingent unsecured liabilities base and assets available to apply to said liabilities. Just a quick snapshot of the valuation methodology applied here. Basically, the liabilities are valued as at the withdrawal freeze, 18 July. And this is an event that affected all users who are contingent unsecured creditors of Zettai equally. This approach has been taken to fix and value liabilities at a specific point, for a fixed point of reference to be able to carry out and communicate a proposed restructuring. Meanwhile, the assets are valued at a more recent date intended to reflect the latest available value of the underlying tokens that comprise the assets. And these assets are identified as tokens that are applicable to the liabilities. Now, while the underlying tokens comprising these assets are substantially unchanged since the withdrawal freeze, they have been and will continue to be subject to any price movements of the underlying assets in line with the volatility experienced in crypto markets. What this means is that the valuation of the assets as at 23rd October 2024 is only a snapshot of the value of the assets at that point in time. And the value will go up and go down in the coming future in line with volatility. As a result of the cyber attack, which did not affect all tokens of the platform equally, being substantially limited to ERC20 tokens, the token denominations of the assets are significantly out of balance from the token denominations of the balances on the platform that underlie the liabilities. As a result, crypto price movements will affect assets differently from liabilities. And what we have done above, fixing liabilities as a reference point, is not sufficient to align the impact of price movements on assets and liabilities. Instead, asset token denominations must be rebalanced against liability token denominations to ensure that that any crypto price movement, which is unavoidable, will affect assets and liabilities proportionately. Rebalancing is being contemplated and planned for as part of this restructuring, pending further consultation with the creditor base. The next section goes into a bit more detail on the key words that we have raised that may need clarification for many users and creditors. Things like restructuring, scheme, moratorium. What are all of these? Let's get into a bit more detail. The first point, what is a restructuring? It's worth clarifying right now at the outset that a restructuring is not an insolvency, it is not a liquidation, and it is not a bankruptcy. Instead, a restructuring is a proposal, a plan by the company to provide an optimal solution for crypto balances held by users of the platform. It is a plan to, firstly, distribute the remaining token assets to users in a pro rata, equitable way, and importantly, in crypto and not in fiat. We intend to make distributions in crypto so that creditors are able to take on any price movements that affect the underlying tokens that comprise their distribution. Now, this is just that point governs what we're going to do with what we already have. That is not all that we are planning for in this restructuring. We are working very hard to actually improve the token recoveries available to users on top of what is already available to us. And this will be done through several ways. First one will be to engage a suitable white knight to provide capital and to pursue any form of partnership or collaborations. We'll also be implementing, with the benefit of a fully functional and operational platform, we'll be implementing revenue-generating products and mechanisms to share the profit of these revenue-generating products with users to improve recoveries. We are also be pursuing and already are pursuing a tracing and recovery exercise for the stolen crypto assets. And lastly, mechanisms to allow users who need to urgently withdraw crypto to do so more quickly and exit the restructuring, while other users who are able to stay for longer will be able to be compensated for this by receiving higher recoveries. So that's a restructuring, which is basically a plan to resolve the situation for creditors. Now, what is a scheme? Firstly, and similar to a restructuring, a scheme is not an insolvency, a liquidation, or a bankruptcy. Instead, a scheme is a Singapore law procedure that makes a creditor-approved and court-sanctioned restructuring legally binding on all relevant parties. Effectively, this is the legal framework that allows creditors to read, understand, and vote for the restructuring plan. And once the creditors approve the restructuring plan, it goes to the court for the court to sanction. And once that is done, it's only then that the restructuring plan will be legally binding. As there will always be a mix of creditors who support and oppose various outcomes, and thus it is essential that any restructuring that we put forward to creditors for a vote be equitable, and it has to be approved by creditors and become legally binding. To be clear, creditors will be able to assess and vote on the proposed restructuring plan before it becomes legally binding under a scheme. And a key part of this restructuring process that we'll be undertaking over the next few months will be a consultative one where we understand creditors' feedback and take comments so we can improve the scheme and ultimately put it before a creditor vote. Now, what is a moratorium? A moratorium is also not an insolvency, a liquidation, or a bankruptcy. None of what we're doing here is about insolvency, liquidation, or bankruptcy. That said, a moratorium is also not a restructuring. It is merely the first step taken to make a restructuring possible. And this is done by protecting Zettai from enforcement action and legal proceedings to give it the time and the breathing space to work with creditors to develop a restructuring proposal that can be voted on and approved by creditors before it goes to court for sanction. Earlier last week, Zettai made a moratorium application to court for a 6-month moratorium, and upon application, an automatic 30-day moratorium commenced, which is ongoing right now. And subject to the court schedule, within 30 days of filing, the court will hear a moratorium application to determine if Zettai should be granted the moratorium that is sought. A moratorium will need to stay in place throughout the restructuring, and Zettai will have to apply for extensions to the initial moratorium if granted, as necessary to ensure that Zettai has the time and the space to progress the restructuring. Creditor support is absolutely key for the moratorium application. The Singapore court will take into account the support from creditors in deciding whether the moratorium should be granted, and we urge all users with crypto balances to show their support via the WazirX app. So these are the last few things that I'd like to define. And it's a question on why are users contingent unsecured creditors of Zettai? I'm going to break this down into 3 bullet points. The first one is contingent. So basically, due to the ongoing dispute with Binance as to the ownership of the platform, And the fact that Zettai is presently handling the crypto deposits, albeit under protest, it's also not clear which entity holds the responsibility for the crypto balances of the platform. Thus, user claims are contingent on the outcome of this dispute. Hence the first word, contingent. Now, what is an unsecured creditor? An unsecured creditor is a creditor that holds unsecured claims. In this case, because of the platform's terms and conditions, the T's and C's, a user of the platform holds unsecured claims for the value of their token balances. Not the tokens themselves, but for the value of. Under the T's and C's, a user can make deposits and conduct trades and will have a claim for their account balances. And in the event that a user makes a withdrawal, in accordance with the T's and C's, Zettai will be liable to transfer those sums to the users if Zettai were found to own the platform with its funds pursuant to the dispute. This relates to the contingency of claim as mentioned in the earlier bullet point. Lastly, why of Zettai? Why not of some other entity? If you refer back to the platform T's and C's, they actually list Binance as a counterparty to platform users with crypto balances. And this is structured to align with Zettai's position in the ongoing dispute that Binance continues to operate crypto deposits and associated activities. Now, notwithstanding this ongoing dispute, Zettai is proactively stepping forward to propose a restructuring to arrive at a solution for users as quickly as possible, because it is in users' best interest to progress this to a solution for crypto balances. Now, as contingent unsecured creditors of Zettai, a restructuring under a scheme can deliver an equitable and legally binding solution for users' crypto balances without having to wait for the uncertain outcome of the dispute. A restructuring is expected to take a significant volume of work, and the scheme itself is governed by legal timelines and processes and court schedules. In terms of the work, what the Crow team is working with Nisha and his team on, along with our legal advisors Raja and Tan, is a few different fronts. Firstly, a detailed analysis of Zettai's financial position, which will be used to develop a restructuring strategy. We also have an ongoing comprehensive white knight process to firstly identify candidates as suitable white knights, speak to them, understand their interests, provide information required for them to understand the situation and for them to do their diligence. And lastly, discuss and negotiate potential avenues for capital injections, rescue financing, or other forms of collaboration and partnerships. This is ongoing. However, we are presently in an ideation stage, and we will provide more information on this process as we progress along the restructuring. Most of the work in this period of time will go towards developing and presenting a restructuring proposal to users as part of a consultative process, where we will solicit feedback from users to improve the proposal. We'll generate ideas, structure it in a way that makes sense to us, but we also want to know if it makes sense to you, because ultimately, whatever we put forward as a restructuring proposal needs to be capable of passing a creditor vote. It needs to deliver what the requisite voting thresholds of creditors want. Lastly, legal timelines. Under a scheme of arrangement, there are specific milestones and a process to ensure that creditors participating in a restructuring under a scheme have access to sufficient amount of detail to adequately consider and make an informed decision when they vote on the scheme. I'll get into more details on the steps in the next few slides. Based on the volume of work which is considerable under this process, court timelines, and court availabilities, we expect that the restructuring under the scheme is expected to take at least 6 months, and is the fastest, most cost-effective, and value-accretive way to deliver an optimal solution that is legally binding to creditors of Zettai and crypto holding users of the platform. What we see here is a list of key dates in the restructuring. The first line basically sets out when we commenced the withdrawal freeze on 18 July. same day as the cyber attack. The trading freeze happened 3 days later on 21st July. The INR distribution happened start of last week, and so did the moratorium application and the commencement of the automatic 30-day moratorium, which is ongoing at this stage. Within 30 days, and of course subject to the court schedule, the court will hear the moratorium application, which is pending. So that is expected by 26 September 2024. And after that, if the court grants the moratorium application as sought over the next 6 months, we expect to be progressing those items and bullet points there. Mainly the development of the restructuring plan, significant user outreach or feedback, and to adhere to court timelines on the scheme process, such as the proof of debt adjudication, creditor voting for the scheme, and finally the court sanction of a creditor approved scheme. And it is only after the court sanction that we can actually implement the restructuring of the creditor approved and court sanctioned scheme. Now, this process is indicative because broadly speaking, while we intend to move this restructuring process as quickly as possible, it may become necessary to go back to creditors for multiple iterations to clarify specific aspects of the plan. So we will push this process as quickly as possible. However, it's expected to take at least 6 months. This is a flow. This slide sets out a flowchart version of what I set out earlier. Now, reading from left to right, the moratorium application is on the leftmost side of the screen. And should the moratorium be granted, basically we go through this extended process for the development of the restructuring proposal and soliciting feedback. And this will have to be under a moratorium. So we will have to extend the moratorium to make sure this process is covered as necessary. Now, once we are in a position where we have a restructuring proposal that we are confident of being able to pass a creditor vote, confident that it can deliver outcomes that are optimal to as many creditors as we can, Zettai will apply to court to convene a creditors meeting to consider and approve a scheme. Subject to the court schedule, the court will hear and approve the application. And then Zettai will issue a notice of the meeting to all creditors detailing what the scheme is about, what are we proposing in the restructuring, and what recoveries can creditors expect to make from it. After a statutory 21 days timeline, creditors will hold the creditors meeting, explain the scheme to all creditors, and creditors will be able to vote on the scheme. And the criteria to pass a vote on the scheme is at least 50% in number and at least 75% in value of each class of creditors present and voting for a scheme at that scheme meeting. In the event that the scheme is approved by creditors, and we're just looking at the top row there, Zettai will have to apply to the court for the scheme to be sanctioned, which is expected to be done within 30 days, subject, of course, to court schedules. And once that is done, Zettai will be able to implement the restructuring under the scheme. Should the scheme not be approved, which is the bottom row, Zettai will have to assess its options. This may include revising the scheme for representation to creditors to cover the key points that were not approved earlier, or a reversion to status quo, which involves progressing the dispute with Binance to a resolution. At this stage, we like to make the point that restructuring under a scheme may be proposed by the company. However, creditors will have to support the process, and the company and Zettai will not be able to pass a scheme without creditor support. As a start, we ask creditors to show their support for the moratorium, because the moratorium will allow breathing space for Zettai to actually develop the restructuring for the benefit of creditors. As the Singapore court will consider the views of creditors and take into consideration when deciding whether to grant the moratorium or not, we ask creditors to show their support. It is in creditors' interest, in our view, to show support for the moratorium, because it is essential to restructuring, which is the most efficient way to a resolution for user crypto balances. and also provides the ability for Zettai to work on improving creditor recoveries. We ask that you show support. We have already received a broad base of support, but we continue to ask creditors for their support to show the court that there is broad support from creditors of Zettai for such a moratorium. You'll be able to show your support through a pop-up via the WazirX app. Creditor involvement in the scheme is going to be an active one. Any restructuring proposed by Zettai will have to be reviewed, voted on, and approved by creditors. Zettai will be providing timely updates over the course of this restructuring, and we'll be working closely with creditors to understand their views and feedback. One such way to do this with 4.3 million creditors is to form what we call a creditor committee. And this is a small group of creditors that we will speak to and work with on a closer basis to understand creditors' preferences and concerns. This will be done to more effectively communicate with what is an enormous number of creditors in total. A creditor committee will be formed in a fair way. The aim is to ensure proportionate representation across various creditors, various categories of creditors to more rightly collect an adequate representation of creditor preferences. Categories such as high value versus low value claims will be evenly represented on a creditor committee to the extent possible. Lastly, I'd just like to reinforce that we will be providing updates via multiple channels of communication. One will be via the platform's website blog and via the official social media channels, X and Telegram. And we have a section on frequently asked questions relating to the restructuring, which we will be refreshing on an ongoing basis to address questions and concerns that are communicated to us by creditors. Your queries are very much important to us, and our support team is operating as usual and ready to receive your inquiries. Please contact them through the chat function on the WazirX app. Lastly, and this is not on screen, you will note that this town hall is labeled as first town hall, and that's because we'll be conducting subsequent town halls when there are material updates that are important for creditors to understand and take note of over the course of this restructuring. So we look forward to speaking to creditors on that in the future. For subsequent town halls, that there will be, as in this town hall, an opportunity to engage in Q&A, to submit our questions ahead of time, and we'll consider them and generate responses and communicate those responses to you during each town hall. I come to the end of the slides. So what we have next is the Q&A session. So we have, before the town hall, in the lead up to the town hall, we put up a Google Forms that allowed creditors to submit their questions. And what we have done is we have gone through the questions submitted. We very much appreciate your participation, everyone. And we have generated a list of the top, the most common commonly asked questions, which are of great concern to creditors, and we think is worth clarifying in this section. So what I'm going to do now is I'll read out the questions that were submitted, and then members of Jason, Nisha, and I will answer them to the extent that we're able to in the time remaining.
George, before we start, I just wanted to inform everyone that we've got a lot of questions. I think thousands of them, and what we've done is we've tried our best to consolidate and get a few questions that are of most importance in relation to the presentation that we made. And we believe the questions that we answer now will help you with respect to what you just went through in the presentation. Having said that, this does not mean that we will not be answering the other questions that you've asked. We are in fact making a list of all those questions, bringing answers to them, and we'll share that subsequently over time. As we get more clarity on many of those questions, as we get a better understanding of some of those questions. But be assured that every question will be answered It's just that we'll need some time. So now what we are going to answer is the answers that we have right now, and which are the most relevant to this presentation. But yeah, over the next few days and few weeks, all of the questions that you've asked in that form, we'll make sure that we answer all of them. Yeah, George.
Thanks, Nishal. The first question, and maybe I can take this one. The question is, what is the rationale behind the moratorium application to the High Court of Singapore, and what specific relief is being sought? Zettai is applying for the moratorium so they will have the breathing space to develop a solution for crypto balances. This moratorium will give Zettai time to negotiate potential investors and pursue a restructuring, which aims to provide an optimal solution for users in the fastest possible time. Zettai is broadly seeking the following reliefs in its moratorium application, which are set out in the affidavit filed on 27 August 2024. Firstly, an order that no resolution shall be passed for the winding up of Zettai. Secondly, an order that no proceeding shall be commenced or continued against Zettai, except with the leave of court and subject to such terms as the court imposes. Thirdly, an order that no execution, distress, or other legal process may be commenced against any property of Zettai, except with the leave of the court and subject to such terms as the court imposes. These reliefs are protective in nature and will allow Zettai to focus its efforts on finding a solution for platform's users. To be clear, a moratorium application is not the full restructuring. A moratorium application only seeks a moratorium from the High Court of Singapore to provide the time and space needed to develop that restructuring for creditors. I got a couple of questions here, more in relation to the restructuring. And the first question is, will Zettai prioritize a few creditors over the others? Let me be clear in stating that platform users with crypto balances are contingent unsecured creditors who rank equally with each other and will be treated equally. Zettai does not have any secured creditors which would rank over unsecured creditors. And so under proposed restructuring, platform users with crypto balances will be treated equally without priority for a few of them over the others. Jason, maybe here's one for you. Why should users bear the legal costs associated with the cyber attack and the restructuring process?
The costs that have been set aside are not just for legal costs. It is to maintain the platform so that we can distribute back in crypto to you with the benefit of this restructuring. It is so that we can reopen operations with the benefit of creditors agreeing, users agreeing to a restructuring, and we can generate profits that we can then share with users to improve recoveries. There are legal costs and advisor costs that are necessary for us to complete this restructuring. And importantly, there are investigative and legal costs that are necessary to try to recover any of the stolen crypto. So, all of these funds that are being spent, which are not small, but they're really necessary to give the best result for all users.
Thank you. Next question. When can we expect trading in crypto to resume? So right now, pending the trading in crypto is not expected to be available until the restructuring proposal has been reviewed and approved by creditors, and voting on the scheme has completed and the scheme is sanctioned by the court. And we expect to be able to resume a broader scope of cryptocurrency related operations like withdrawals and trading only in line with the terms of the scheme, which will take at least 6 months. Here's a question, and Jason, let me know if you want to address this. If not, I will. Is there a plan in place for compensating users who lost funds due to the attack?
The plan to compensate is exactly what we're talking about. It's get as much back as quickly as possible to all users in a fair and equitable manner. Over and above what we're holding at the moment, the assets that were set out earlier by George, we're working to try to get potential investors, white knights, to contribute funding. Those discussions are ongoing. We're working to recover some of the stolen assets, and we're looking at profit sharing arrangements going forward. So we are doing the best we can to reduce the amount that was stolen. And I guess that is the form of compensation that we're trying to pull together for you.
Thank you. Next question. What is the expected timeline for the restructuring process and resolution of the moratorium application? Why is a 6-month duration necessary, and can it be shortened to 1 or 3 months? I'll take this one. This expected timeline is at least 6 months due to the huge amount of work needed to develop this plan and to socialize and understand feedback from the creditor base. There are 4.3 million creditors, which is an enormous number of creditors to work with. This will be a very involved process, and we want to know what creditors think about our proposed terms so that we can improve the terms to cater to creditor concerns. There also needs to be time taken for that specific set of legal timelines associated with the Singapore Scheme of Arrangement, which is in place to ensure that creditors have access to the requisite amount of disclosure needed to properly understand the proposal put in front of them and be able to make an informed decision. There are also an additional layer of court availability. As noted in the timeline that we set out earlier, there are multiple times where we will have to go to court for approval of certain steps, such as extension of moratorium, as convening a creditor meeting, as sanction of the scheme. All of these are subject to court availability and timetables, which is why we expect that it will take at least 6 months. However, the intention is not to take 6 months if we don't need 6 months, and we are looking to expedite it to the extent possible.
And I mean, but basically, guys, of the 4+ million users, we're never going to be capable of getting 100% of 4+ million people to agree to what's proposed. Different people have different views, and without that, we have to have a process that can bind creditors, and this is the quickest, most efficient process that can do that. It's unfortunate that we need this time, but it is the only option, and it's the quickest, cheapest option.
Here's a question. Will an increase in crypto asset values or prices help WazirX's financial positions? Let me take this one, Jason. Broadly speaking, what we showed on screen with respect to the asset base is shown as a valuation snapshot in one point in time, based on a base of tokens valued at that day using the token prices of that day. Over time, the prices will increase or decrease depending on the volatility of the crypto market, which means that your assets are going to go up or down in value over time. What this means is that the value of the crypto assets can change relative to liabilities. However, what we can't say is that we know what the token recoveries are going to be, because presently assets are the tokens underlying the assets are significantly out of balance compared to the token denominations underlying the balances on the WazirX platform. As elaborated on earlier, assets will need to be rebalanced with the token denominations of liabilities to ensure that price changes up or down, as applicable to assets, will also be equally applicable to the liabilities. And this cannot be understood at this stage. It can only be understood following a rebalancing, which requires a bit more internal assessment, and we are looking to consult with creditors on this. Let me jump over to a couple of questions more on the legal front. And Jason, maybe this is for you. Why are only cryptocurrency balances being restructured? Why are INR balances not also being restructured?
The INR balances were handled by Zettai, the Indian entity, and they were not affected by the cyber attack. So we, as mentioned, were able to distribute those, and that's happening now, which is great. The crypto is handled by Zettai, the Singapore entity, and as mentioned, we have to have a resolution to bind all of the users here, because we're just not capable of getting 100% agreement from more than 4 million people.
Next question. Since users didn't sign any T&Cs with Zettai, why are we conducting the procedure in Singapore and not in India? I'll take this one. Zettai is a Singapore incorporated company, and it took custody of the platform's assets following the ownership dispute with Binance. If Zettai is determined to be the owner of the platform and its assets pursuant to this dispute, the platform's users will be creditors of Zettai. And until this happens, the platform's users are contingent creditors of Zettai and not direct creditors. In the interest of the platform's users to get to a solution as quickly as possible, Zettai is proactively stepping forward to propose a restructuring of the platform's crypto balances so that users don't have to wait for the resolution of this dispute with Binance, which is uncertain and will take an uncertain amount of time. It's also important to note that Zettai, as a Singapore incorporated entity, is able to use the scheme of arrangement legal framework in Singapore law, which will be the fastest and most effective way to arrive at a compromise and bind creditors to an outcome that most of them have, that enough of them have voted for, in line with the voting thresholds of a scheme of arrangement.
And guys, I'm in Mumbai today. You know, we're lucky we can use the Singapore process here. You know, I work in India on similar matters like this, that there isn't a system here that would be quicker or more efficient. So we're fortunate we can take advantage of Zettai holding the crypto and use these proceedings. 6 months will seem a long time, but that is a relatively quick and efficient process to deal with something like this.
Yeah, I think I also wanted to just clarify a bit more on this whole, because I think there's a lot of confusion on why is Zettai coming in. Maybe to give an example to everyone, if you look at crypto and you're trading on a lot of exchanges, and there are exchanges which are not necessarily having an entity in India, because you're only dealing with crypto to crypto there. And they would have an Indian entity only when they bring in the INR component, if they were to provide INR. In the case of WazirX, when there was a banking ban, there was no INR, and there was crypto to crypto trading. And it was during this period that the acquisition was done by Binance. And that is where the Singapore entity was involved in selling the platform. And after the acquisition is where INR came into the picture in March 2020. And that is the time when the Indian entity entered and said, we'll start accepting INR and deposits and processing the withdrawals for INR. So it came in later. The crypto to crypto part existed on WazirX even before then, and that's where the Singapore entity was part of owning the platform. So now, since there is a dispute, the Singapore entity is stepping in order to ensure that the platform users don't have to wait for the dispute to resolve, and can we on an expedited manner bring a resolution here despite the dispute. Otherwise, everyone has to wait for the dispute to consider who the ultimate owner of WazirX would be. But that still does not mean that the India entity comes into the picture, because it is only dealing with INR. And it came in only when the INR option started in India, which was in March after the Supreme Court ruling. So I wanted to clarify this, because there's a lot of confusion on India entity and what is its role. It is only to do with the INR part. Yeah, Josh?
Yep. Another question. You have maintained that crypto assets were affected by the cyber attack and INR was not affected. You further confirmed that Zanmai manages INR-related operations and Zettai handles crypto deposits. In this situation, why did you file the FIR in India and not in Singapore? Why do you engage the India CERT team and not the Singapore CERT team? I think the way to answer this question is that, firstly, this cyber attack was unprecedented. It had huge consequences. And in the aftermath of the cyber attack, both Zanmai and Zettai reached out to the relevant authorities in both India and Singapore so as to get a better understanding and aid investigators in their investigations. This is not the case that we are only filing in one jurisdiction and not the other, and we are working with a wide range of investigative agencies, both in India and in Singapore, and we will keep the platform's users, apprised of any developments on that front, along with any developments on our efforts to trace, tag, and recover any of the stolen assets.
Yeah, I think just quickly, like the simple thing about this question was, if you're saying the Indian entity is only handling INR, why is the Indian entity filing FIR in India? And why not the Singapore? And the answer is that we want to try everything possible to recover your assets, and we don't want to, leave any stone unturned. And that's why it's not just India, but even Singapore, and not just these two. We are going to go to every country that exists if there is a way for us to recover these assets. So we are not going to just stop at India or Singapore. We'll continue to, make sure that we put all our efforts to recover your assets. And if it means going to 10, 20 more countries, we'll do that as well. Yeah.
Thanks, Nishal. Jason, I've got a question for you. Given the ongoing dispute, does current management have the legal authority to enter into and close deals with potential white knights in the effort to work in collaborations and partnerships with them?
Yes, the directors remain in control of the company, but the creditors have the right to approve a scheme here. So any deal done with a white knight is something that will be put before you guys for your consideration. We'll explain why we're doing it, how we believe it will help recoveries, and estimate how much it will help recoveries. And then ultimately it will require your approval of 75% in value and 50% in number. So yes, the creditors are doing their best to pursue all avenues of recovery and investment like a white knight. They are absolutely authorized to do that, but it really is only for the purpose of presenting a deal to users.
Thank you. Couple more questions on the security aspects. And Nishal, perhaps this is one for you. Can you provide a detailed explanation of how the security breach occurred and what specific vulnerabilities were exploited? How can we get more information on this security breach?
Sure. I think I touched a bit upon that towards the beginning. And the second part of the question, how do we get more information? We've put a lot of blog posts which details out. In fact, one blog post completely details out the steps that we believe led to the breach. Having said that, to give a quick answer to this, there were 4 signatures needed, 3 signatures from 3 WazirX employees who sit in 3 different locations. And they were using their laptop. They logged into Liminal's website, and they initiated the first person initiated a transfer for Gala tokens. And on their Ledger device, they approved it because on the Liminal website they saw that the transfer was for Gala. On Ledger device you can't know because there is blind signing, so they approved. Then the next person, they saw on the website on Liminal's website that it's a transfer for Gala. They approved it, and then the third person, and then fourth will be Liminal, where it's not a human sitting, so they're not using a manual ledger device to see. It's a system that understands that a particular transaction has to be done. They have firewall and they have whitelisting, where they're supposed to only approve transaction to specific addresses that we have added before. Unfortunately, this was a malicious transaction that was also signed by the fourth signer on Liminal's end, and this transaction led to the attacker getting ownership of the smart contract, which held all of the funds. To make it simple, what that means was, after this transaction, the attacker could transfer all of the assets on their own without needing any more signatures. And this happened on the 18th of July. And yeah, on our end, what we've done is we've gotten our 3 laptops that were involved in signing. We've gotten the best forensic team to do an analysis, and they've said that these laptops were not compromised. Now we are waiting on Liminal to provide information. Having said that, we are also working with law enforcement. We're not just working on internal investigations. We are working with law enforcement. We've given all our laptop images to the law enforcement right in the beginning whenever they ask for it. So law enforcement will take their own investigation, their own course, and all of us as entities that are involved in this, we are taking our own steps to make sure that there is absolute clarity on what has happened and where does the breach lie. At least our laptops are clean, and we know that, and that's our only involvement, which is use a laptop, log into Liminal's website, approve a transaction using a ledger hardware device. Our WazirX systems, WazirX servers, they had no role to play in this, because this was cold wallet, which was outside the infrastructure of WazirX. Yeah, Josh.
Guys, this process has been an involved one, getting to the bottom of how the hack occurred. Then the next question is what happens next? What are we doing to trace and tag and pursue these assets? This is also ongoing. In addition to that third-party security assessment that Nishal mentioned earlier, we're working with Zero Shadow to trace these assets on the blockchain, and we're also working together with a third party from the company, a blockchain forensics expert team from the Crow IDC platform, that will put together, for the benefit of the court and for creditors' understanding, synthesize the findings made on both the security front and the tracing front, assess and generate a likelihood of recovery, and generate recommendations for management as to next steps, so that it's clear to everyone the key avenues of approach and strategies for recovery of the stolen assets, which will be used to improve creditor recoveries under restructuring. I've got a couple more questions, and I think this relates. We're coming to shortly to the end of the list of questions. Of course, there will always be more questions submitted, and we're happy to address them in writing in the FAQ section of the blog. But for now, we've got 2 more questions, and this is in respect of recovery potential under a restructuring. So a question here would be, under restructuring, is it possible to recover more than 100% recovery in token terms? And is it possible to recover more than 100% in fiat terms, USD value? Jason, do you want to do that one?
Sure. It's highly unlikely that there can be a recovery in crypto terms at 100%. The present numbers indicate a range of 52 to 57% in crypto terms. We're working to recover the stolen crypto. We're working with investors to potentially contribute funding. And we are happy to share profits of the platform going forward, but we don't know yet what that will be. But I do think it is highly unlikely we can bridge that 43 to 48% gap, unfortunately. But we're doing the best we can to improve it as much as possible. In fiat terms, The portfolio is presently held in crypto. Crypto can go up. And so it is certainly possible that if crypto goes up substantially, then the fiat recovery will be more than 100%, yes. The portfolio is not presently balanced with what users have in their accounts because of the cyber attack, and that is something that we'll have to address as we go forward as well, ideally so that the portfolio is balanced with what proportion of the crypto that you are entitled to.
Thanks, Jason. And on to our final question for now. Can you elaborate more on your proposed approach under restructuring when it comes to fixing your liabilities at a specific point in time and generating token distributions from that fixed base on liabilities? Perhaps let me take that one. So right now, the present thinking for the restructuring aims to crystallize your the liabilities arising from crypto balances on the platform into a fixed USD value as at 18 July 2024, which is the date of the withdrawal freeze. Now, each creditor will own their share of this overall amount, right? And it's about 544 million. So each creditor will have a share pro rata to the value of their claim divided by the value of all claims. What we're thinking to do right now over the progress of this restructuring would be to rebalance the crypto assets to ensure that the token denominations of the crypto assets be aligned against the token denominations of the token balances on the platform. And creditors will be able to get the opportunity to choose which tokens to have that they would want to receive distributions in, and as a result, have market exposure to. Once you have done the rebalancing, we'll be able to understand and lock in a specific percentage token recovery for each token. And once we redistribute these rebalanced crypto assets, any pricing movements on those tokens will also be borne by creditors when they receive these token distributions, which brings us to a scenario that Jason mentioned earlier, that even though the token recoveries will be fairly fixed after a rebalancing, of course, potentially with improvements from white knights, revenue sharing, and stolen asset recovery, pricing movements on those tokens, if the price of the tokens go up, users who receive these distributions of tokens will be able to get the benefit of those increased prices. And as a result, in certain cases, these recoveries can actually exceed 100% in alignment with high crypto price movements in the market. Okay, we've come to the end of the list of questions for now. Jason, Michelle, is there anything else that you would like to address?
No, I'd just like to say thank you for your time today and all of the questions that have been submitted. We're here to help. Please feel free to submit further questions. We know that a lot of this is confusing. I'm sure that we haven't been able to answer every question that you have, and more would have occurred to you as we were speaking. Please reach out to the details provided in this presentation, and we will do our very best to respond as quickly and diligently as possible. We're here to make this as efficient and the best process that it can be in these unfortunate circumstances.
Yeah. I just want to say that our objective is to resolve this as soon as possible. Having said that, this process needs to be explained to everyone, and we are trying our best to do that, and also answer any of the questions that you might have. Because before we get into the final part of this entire process, which will be where you'll decide on the scheme, we want to make sure that we get as much feedback from you and work with all of you to put this together so that we can resolve it in a manner which works for everyone. And we are here to answer all your questions around that. Even things may not be completely clear for, if they're not completely clear for you, don't be worried, because this is just the first of the town hall. We'll have a lot more FAQs answered. We'll have a lot more interactions, formal, informal, in whatever way we can. Because our objective is to make sure that you're completely clear about the process, and you're involved in the whole putting together the scheme. So we'll keep you completely updated all the time. This is just a start of this whole discussion and clarity, but expect a lot more clarity to come as we get to hear from you the feedback and your questions and suggestions on this process.
Thanks, Jason and Nisha. As a final note, everyone, thank you so much for your time. We aim to make this as clear and efficient as process as possible. We will be updating FAQs. Please submit your questions and we will address them as and when they come in, to the extent that we're able to. And as a parting comment, I will very much appreciate if you could show your support for the moratorium. This will be an essential part of the restructuring. We need your support for the moratorium to make the restructuring possible. And we very much want to pursue the restructuring for the benefit of creditors, because this is an awful situation. And our hearts really very much go out to creditors, and we want to work with you to deliver an optimal situation. Please support the